child advocate.
Right.
Good morning. This is the Senate Health and Welfare Committee. It is the Ides of March, and we are after crossover, which is a good thing. Everybody's been working, burning midnight oil, so now we can feel a little bit refreshed and looking forward to additional bills in front of us from the House. And the two bills that we're looking at today, the Office of Child, Youth, and Family Advocate is one that we've seen before, and the other is the Medicaid reimbursement for home and community-based service providers, is also one that we've seen previously, but it doesn't hurt to go through those two, and so that we can figure out next steps and what we're going to do with each one. So we'll start with Dan and Representative Noyes and Representative Pahala, thanks for being here. Why don't we begin with you, and you go right ahead as you see fit with a short introduction to the Child and Family Advocate bill.
Great, thank you, Senator. So we've started working on this bill last session and passed it out of the Human Services Committee, and here we are. I think the overall idea is, how do we make sure that our systems in state government provide the best opportunity for youth to transition to adulthood who are in the custody of the state? And in doing that, it's just, we tried to come up with this advocate who would kind of look at the big picture of how the state is providing services, education to youth who are in the custody of the state. So that's kind of a big picture overview of what our ideas were, and and then we kind of drill down and look at the individual pieces of it within the bill, how it's set up, how they get their information from advisory committee, and then so kind of that's a big picture. Representative Pahala, would you like to add any?
Not right at the moment. If Katie's doing a walkthrough, that's probably the most helpful thing to have.
I'm having a hard time hearing you, Representative Pahala. There's a little bit of distortion going on, so, and I don't know whether I don't know what's causing it. But.
Well, is that better?
Yes.
It's not better.
It's not better for everyone, but it is better, I think, overall.
Okay. Well, I would say Katie should probably do a walkthrough, and then we can.
Okay, good. And we'll ask questions as we go along. Can I just ask one upfront question? Did you at any point consider keeping an eye on kids who might be in residential facilities in the state? I see heads shaking.
Yes, we believe that would fall under the purview of this.
Okay, but for kids in custody, but what about for kids who are not in custody, who are coming from out of state into residential facilities? Okay.
We might have to make sure that ends up falling under the purview.
Okay, thank you. Thank you, Katie.
Yes, Katie McGlynn, Office of Legislative Counsel. We can sort of slow down on that section when we get there to look at the language and see what it may or may not cover.
Okay.
Okay, so this is H265. The House passed this last year. And as we go through it, you'll see a lot of dates will need to be updated and changed as we go through if you were to pass this out. So this creates the Office of the Child, Youth, and Family Advocate and creates a new chapter within Title 33. The first section is a definition section, so I'll kind of skip by that for the moment. And the next section is section 3202, and this really establishes the office. And I think this first paragraph sort of is grounding in what the goals of this office are and what this office will be focusing on. So I'm gonna slow down and read that language. There's the Office of the Child, Youth, and Family Advocate for the purpose of advancing the interests and welfare of Vermont's children and youths receiving services from the department in a manner that addresses racial and social equity, including providing transparent and impartial oversight of the child protection and juvenile justice systems, and promoting reforms necessary to better serve Vermont's children, youths, and families. The office shall act independently of any state agency in the performance of its duties. So it's an independent office. Subsection B of this section goes into all of the responsibilities of the office. And as I was looking through this yesterday afternoon, it struck me that I had gone through it recently. I did walk through it with this. Okay. So if I'm repeating things that you already know, you can tell me to go a little faster. But as we look through this list of responsibilities, subsections 1 and 2, or subdivisions B1 and B2, those two responsibilities sort of kick in before some of the other responsibilities. The idea is that the office and the advocate sort of get boots on the ground, get their feet under them before they add the rest of the responsibilities in the mix. So I think it's about 6 months when the office first is up and running that subdivisions 1 and 2 are the only one in play. So first, work in collaboration with relevant parties to strengthen the department's services for children, youths, and families. And second, analyze and monitor the development and implementation of federal, state, and local laws, regulations, and policies relating to child, youth, and family welfare, and recommend changes when appropriate. Subdivision 3 is reviewing systemic issues in the department's provision of services to children and youths that may exist, and complaints concerning the actions of the department and of any entity that provides services to children, youths, and families through funds provided by the department. Make appropriate referrals and investigate those complaints where the advocate determines that a child, youth, or family may be in need of assistance from the office. Fourth, supporting children, youths, and families by providing information about recipients' rights and responsibilities related to departmental services. Reviewing current systems to determine to what extent children and youths placed in the custody of the department or who are receiving services under the supervision of the department receive humane and dignified treatment at all times, including consideration by the advocate as to what extent the system protects and enhances the child's or youth's personal dignity, right to privacy, and right to appropriate health care and education in accordance with state and federal law. Subdivision 6 is providing systemic information concerning child, youth, and family welfare to the public, the governor, state agencies, legislators, and others as necessary. Subdivision 7 is working on an annual report that addresses the following: the quality of services provided to children, youths, and families, the conditions and placements for Vermont's children and youths, systemic findings related to services for and assistance to children, youths, and families within the child protection and juvenile justice systems, recommendations related to improving services for children, youths, and families, and data disaggregated by race, ethnicity, gender, geographic location, disability status, and any other categories that the advocate deems necessary. And the last responsibility is addressing any challenges accessing information or records that are necessary for carrying out the provisions of this chapter. So those are the responsibilities of the advocate in the office. And then at the top of page 4, section 3203 sort of talks about how the advocate is selected and how long that term would be, how the person could be removed from that position. So in subsection A, we have that the office is directed by the advocate, who is an individual qualified by reason of education, expertise, and experience, and who may have a professional degree in law, social work, public health, or a related field. And the advocate is to serve on a full-time basis and shall be exempt from classified service. In subdivision B1, we're talking about an oversight commission on children, youths, and families. So there is an oversight commission. It's established at the end of this chapter, so we haven't looked at it yet. But this is sort of like the steering commission for the office that kind of sets like the goals and the direction of the office. So this group shall recommend qualified applicants for the position of advocate to the governor for consideration. Subject to confirmation by the Senate, the governor is to appoint an advocate from among those applicants recommended by the Oversight Commission for a term of 4 years. The appointment for advocate shall be made without regard to political affiliation and on the basis of integrity and demonstrated ability. The advocate shall hold the office until reappointed or until a successor is appointed. In subdivision 2, this is how the advocate is removed. The governor, upon a majority vote of the Oversight Commission, may remove the advocate for cause, which includes only neglect of duty, gross misconduct or conviction of a crime, or inability to perform the responsibilities of the office. And the governor's reason for removing the advocate shall be published electronically on the website of the advocate, and the speaker and the pro tem shall simultaneously receive notification. Any vacancy is to be filled by the appointment process that was set forth above for the remainder of the unexpired term.
Is that, yeah,
So, yeah, go ahead.
is that process unique, or are there other positions that sort of follow this kind of process?
I think it's fairly unique. I'm trying to remember if there's a healthcare position.
Healthcare, what's legal aid though?
Healthcare advocate?
Yeah, what about, yeah, that's a good one. What about healthcare?
I'm not sure. I'd have to look to see.
We'll have to get testimony on that.
Yeah,
And who's the commission comprised?
I'm sorry.
The commission, or the oversight commission?
The Oversight Commission.
Yeah, and that's in 20. You know, who makes up that?
We'll get to that. That's in the last section of the chapter. Yep.
Thank you.
Do you think that either of the reps will remember this, or is that something we should have? Maybe it wasn't a question that was asked.
They took quite a lot of testimony upstairs, so they might recollect if we used an example from existing law for that process, but
Well, Ruth, why don't you ask Representative Paul that question?
We were just thinking that it might have been from the, the Office of Racial Equity.
Oh,
That's what we were remembering, but you should double check that.
The Office of the Director of Racial Equity, is that, okay?
go ahead.
Okay, I have some questions for, I think Representative Noyes, because I'm having trouble hearing Representative Pahala. What problem are we trying to solve?
With the advocate's office?
Yeah, with the whole thing.
Okay, that's a good question to ask.
What problem are we trying to solve? We're trying to make sure that youth have the best opportunity to be successful. And you know, when we look at Woodside and Kernhattan and other, you know, Woodside, you know, how do we make sure that doesn't happen again? How do we make sure that people have the best you know, youth have the best opportunity to thrive? And also, when you look at our legislature, you know, are we, how do we get information on what are the best practices for legislation around children and youth? You know, and this Office of the Child Advocate would be able to help guide us with those decisions, would be the hope.
It seems to me that this oversight must be happening throughout the system in sort of in pieces. And it sounds as if something like this advocate would bring it all together under one roof.
And we really thought about the access to information, whether it's from the Department of Health, Department of Education, or Department of Children and Families, and you know, making sure that the advocate did have access to all that information so that they could really look at the big picture systems and try to make sure that it's functioning properly.
Just wonder if it's a huge job for one person.
Well, I mean, this is really the right question to ask as we take testimony about this position. And understanding what is currently happening or not happening, and then what this position or individual might do to have a better outcome. We'll just have, Senator Cummings' question is one we're gonna have to keep moving forward with. Thank you. Any other questions at this point? Okay, go ahead.
So I was just trying to rack my brain about what other kind of positions have a nominating board. And I was remembering that there's the Green Mountain Care Board nominating committee. So that's another, but they are confirmed, let's see. They have terms of 7 years. So a little bit different, but they do have that nominating.
Yeah.
But they are more, they were set up to be more like the judiciary, I think.
Quasi judiciary.
Yeah.
It's a pretty heavy duty process. And we just finished one over the summer. I was on it, and I was on the previous one, and it is fairly in-depth. Let's look and see what this commission is
Okay,
doing,
And I'll look
and then
at
who's
the-
on it, because that will give us a clue also.
sure. And I look at the Director of Racial Equities nominating language
Okay.
to see if that is comparable or where this was pulled from. Okay, so we're on page 5 of the bill as passed the House, subsection C. This is that the advocate shall appoint a deputy whose duties shall be performed at the direction of the advocate. And then in subsection D, upon any vacancy in the position of the advocate, and until such time as a replacement is appointed and confirmed, the deputy child, youth, and family advocate is to serve as the acting advocate. And the acting advocate shall have the full responsibilities of the advocate and shall be entitled to the same compensation as the outgoing advocate. The next section, 3204, is the Child, Youth, and Family Advisory Council. So I just want to make a distinction because we've been talking about the Oversight Committee, which is like the steering committee. And this council, the Advisory Council, is in more of an advisory role. And these are made up, the committee council is made up more of people with lived experience of being involved in the DCF systems, and this group also expires. So the idea is that this group is only in existence for a handful of years until the advocate's office is sort of up and running, has its feet under it, and then it is set to expire, whereas the Oversight Committee does not expire. So this advisory council, the advocate is to appoint and convene an advisory council composed of 9 stakeholders who have been impacted by child welfare services provided by DCF. The council's membership shall reflect the growing diversity of Vermont's children and families, including individuals who are Black, Indigenous, and persons of color, as well as with regard to socioeconomic status, geographic location, gender, sexual identity, and disability status. Members shall provide advice and guidance to the office of the Child, Youth, and Family Advocate regarding the routine administration and operation of the office, including providing advice and guidance to the advocate upon request. We have a date for the first meeting, which we would have to push back if this were to move forward. The group selects a chair from among its first meetings. Majority constitutes a quorum. Yeah. Oh, is it today?
Yeah, this is
Okay.
it, this is it.
We better hurry. Get on that.
I was waiting for you to get there, and it was just like you kept going.
Oh, gosh. And then the advisory council, as I said, ceases to exist. This date has it as July 1, 2028. Subsection C is the confidentiality language. In seeking advice and guidance from the council, the advocate is not to disclose to the advisory council or any member thereof individually identifiable information about a child or youth unless the information is already known to the public. There's language about per diem compensation and reimbursement of expenses for not more than 12 meetings annually, which are made out of, the payments are made out of monies appropriated to the office. And then page 7, section 3205, incidents and fatalities. The department is to provide the office with a copy of all reports related to actual physical injury to children or youth in the custody of the commissioner or a significant risk of such harm. And then in subsection B, the department shall provide the office with a written report within 48 hours of any fatality of a child or youth in its custody and the restraint or seclusion of any child or youth in its custody. So this is information that the advocate doesn't have to ask for. This is information that just automatically comes directly to the advocate. In section 3206, access to information and facilities. In subsection A, the advocate shall upon request have timely access, including the right to inspect and copy any records necessary to carry out the provisions of the chapter, including relevant records produced and held by state entities and third parties. So like I said, this language is upon request. This is a little bit different. This is the advocate going out to seek this information. And subsection B, the advocate and deputy advocate may communicate privately and visit with any child or youth who is in the custody of the department. The advocate or deputy advocate, have to obtain the consent of a parent or guardian prior to communicating or visiting with a child or youth who is not in the custody of the department.
All right, let's go through that one.
Yep. So if a child or youth is in the custody of the department, the advocate and deputy advocate can communicate privately and visit with that child. In order to do the same with a child who is not in the custody of DCF, the advocate or deputy advocate would have to seek permission from that child or youth's parent or guardian.
So, okay, I want to put this in the context of Kern Hat, because that continues to be a big concern, where there's, if the residential school or facility is not certified by the state and there's no kids in the custody of DCF, so these kids are just here in the state. This would mean that the advocate would have to identify a parent or a guardian out of state and ask for permission to investigate.
Yes.
There's nothing here that would allow for, if there were any kind of, unless, if there's a complaint. So if there was a mandatory reporter coming out and saying, you know, that we feel this child is being abused, would that allow for that to occur?
So the mandatory reporting procedure is still in place, and that this doesn't change that at all. So that would still be happening. What
I'm going to just ask the question, is the mandatory reporter anywhere in this bill reporting to the child advocate?
this bill adds the child advocate as a mandatory reporter.
But it doesn't add anybody reporting to him or her.
No, but it allows
Yeah.
the advocate to obtain related records.
Okay, so I feel a catch-22 coming along where, as a mandatory reporter, I see kids in this residential facility and I'm hearing things, but I have to get in touch with a parent or guardian to know. I think trying to sort out what
Sure.
role it might play.
Let me see if I can help a little bit. So the language we read was just about having private communications and visits with the child.
Okay.
It does not have anything to do with accessing the facility itself or accessing documents. So this parent permission to have a private communication or visit with a child, the parent permission only goes as far as that private communication. The parent doesn't have to weigh in before the advocate goes into the facility to sort of observe what's happening there.
Okay.
And like I was saying, in the paragraph subsection A, the advocate has timely access including the right to inspect and copy records necessary to carry out the provisions of the chapter. So you don't need, the advocate doesn't need parental permission to access documents that are relevant to the advocate doing their job, including records held by the state or records held by third parties. And then in subsection C, this is the language about the facilities themselves.
Okay,
So the facilities and providers delivering services to children and youth shall permit the advocate or deputy advocate to access their facilities and communicate privately and visit with children and youth for whom they provide services.
and how broad is that? Is that any children and youth?
Well, you know, that's interesting because the language above says it's only in custody, and here,
Yeah,
if it's a facility providing. So I think that maybe this committee wants to take a deeper dive into those two sections to think about how they work together.
yeah, I think we should. So we're certainly continue to be concerned about the current Hatton situation, among others. So let's flag that. And as we take testimony, we'll have to be asking about that.
Yeah, I think I need to know what happened or didn't happen at current Hatton and Woodside. I think they're very different
Yes.
situations. And we're setting up another whole bureaucracy. Is there something we could do within the present system to prevent? Because this is hugely broad for two people.
It is, so, and
Yeah.
I think that the representatives would probably agree with that assessment. It is broad, yeah.
I mean, it's definitely going to have to grow if it's gonna do half of what
Yeah,
it's supposed to do.
yes, so the sky's the limit.
Somebody better tell appropriations about that.
I thought that was a joke. Okay, all right, no, it's not that we're making any decisions here, we're just
No,
asking
it's-
questions. We wanna understand, and we need to be thorough and trying to figure out, is this the right way to go at this point? We understand the House has done a lot of work and believes that it is, but the question about Woodside, the question about Kern Hatton, and then there are other residential facilities, that last piece feels pretty big, anyway. But it may be a good thing. It may be a good thing, so let's just keep that in mind as well. Representative Noyes, did you want to comment?
Yeah, I just think in section A, that last part of that section where it says that they have access to records from third parties may capture a lot of, places like Kern Hatton where they're able to look at the records and not necessarily talk to youth that aren't in state custody, but at least have the opportunity to see what's going on in the records there. And it could be any entity in Vermont that has, or even out of state was what I think we were really talking about also, because there are a number of youth that are placed out of state.
Okay. And I know. It's coming since already.
No, I'm just thinking, we don't have a residential place for adolescents with autism. They are placed generally by their parents. Are we saying the state of Vermont can go into a private residential facility in New Jersey because a parent has placed a Vermont child there? I think we might get some pushback.
No, I would say that if they were in the custody of the state, but if it was outside of that, then probably not.
I think we need to make that clear.
Yeah, those are important points. We also have the Interstate Contract.
Yeah, I was just thinking.
Yeah,
how
really
does this
good.
interact?
And it also, what we're passing over you guys, but it does define some of this and the authority that the state has out of state.
Right, and we can't change it, so I'm wondering if this is consistent with it or contradicts it or in any way.
That's a Katie Michelle Childs question.
Yeah,
Yeah, that would be interesting to look at.
But
that.
since we have it and it hasn't gone to the House, can I assume that the House didn't look at
No.
the interstate child placement compact
They did about,
when you did that, because it hasn't come to you yet?
I think we did, and I think we made some changes to that last session.
yeah, you did. You added a legislator to the council, the in-state advisory council.
But we can't change it.
Right, okay, that's what it was, yes. Wasn't it, was it 2 years ago?
I think it was 2018 or 2019.
18? I remember
Yeah.
talking about it in committee.
I forgot.
Sorry, I'd have to go back and look.
Don't worry, be happy. Okay. Ruth, did you have a question?
no, my question was how it interacts with the interstate compact
Oh,
and
yeah,
whether
okay.
it contradicts or anything,
And
so.
I guess my question is, like you said, Representative Noyes, that this is to make sure that children are getting the best possible care. I need to know what is happening throughout the system now and how we can facilitate this. I understand, I can see the need for bringing everything into one place so that we have a good picture of it, but it seems as if a lot of this should be happening. If it isn't, then this is.
Yeah, it's a good question, and I know that we did take testimony on that during 2 different sessions of Child Advocate Oversight Committee, and we did hear from DCF about this. The issue that the tension is, are there sufficient resources within DCF to provide that oversight, and
They're short-staffed.
So do we add another layer or do we
good
put more
question.
money into
I mean,
what's already
Two
here?
people is at least $200,000. Just the rough $100,000 per position. Plus,
All right,
yeah,
There's a fiscal note.
There's a fiscal note.
there is a fiscal note.
how close was it?
You are pretty darn close.
Let's keep going through the bill, and we're asking all the good questions, and I could see concerns written on some faces and relief on others, so let's keep going, Katie.
Okay, so we're on page 8, section 3207. This section says that all state agencies shall comply with reasonable requests of the advocate and deputy advocate for information and assistance. And we have confidentiality language in 3208, that the office is to maintain confidentiality of all records, case records, third-party records, court records, as well as any information gathered in the course of investigations and systems monitoring duties. So records are exempt from public inspection and copying under the PRA and kept confidential, except as provided in B and C. So A is sort of the rule, B and C are the exceptions to the rule. In subsection B, in the course of carrying out the provisions of this chapter, the advocate or deputy advocate, if the advocate or deputy advocate reasonably believes that the health, safety, or welfare of a child or youth is at imminent risk, the advocate or deputy advocate may disclose relevant documents or information to any of the individuals listed in existing law of this title, and determinations of relevancy shall be made by the advocate. So there's existing language in state law about who can have records relevant records upon request that have to do with records of abuse and neglect. So that list includes a licensed or approved foster caregiver for the child, mandated reporters, the family division of the Superior Court, educators working directly with the child or family who is subject to the report or record, health and mental health care providers working directly with the child or family who is subject to the report, a person, agency, or organization, including a multidisciplinary team, to diagnose, care, treat, or supervise a child family who is subject of a report or record created under this subchapter, or who is responsible for the child's welfare. So the advocate may disclose any relevant documents to individuals that are already on this list to receive documents. And subsection C.
Just a comment there, so it feels like that with the child advocate being able to look at educational issues, DCF issues, Department of Health issues, and it's a whole child perspective that there's an umbrella for all the possible places where we might see a child, abused or neglected, so, or needing support or services. So it's a one place where all of that information can go. That's a comment. Go ahead, Senator.
Is this, I'm trying to figure out how much of the child advocate is for children writ large and how much of it is for individual children. And it seems like it's kind of both. Yeah.
I think so. I think, we could go back to that first section that lays out all the specific duties, but some of the specific duties have to do with, looking into a specific case. Other things have to do with, systemic reporting and understanding the statistics and the demographics. So I think this office looks at both the systems and is a resource for individual families and children and youth.
And would they be, sorry, Senator Cummings, would they go to court cases or custody cases or cases of
Adjudicated
placement or anything like that?
This language doesn't direct them to do anything like that. They do have access to records to pull from, judicial records, but the language itself doesn't seem to anticipate that person is necessarily in an advocacy role on behalf of the child.
Right, even though they're the child advocate.
Oh.
That's why I was trying to figure out, like, are they literally the courtroom advocate,
Yeah, no,
Okay.
this legislation doesn't anticipate that they're in the courtroom advocating on behalf of the child. Not to say that there's anything in the language, preventing them from, presenting information or something like that, but this doesn't direct that type of activity.
Okay, thanks.
Senator?
No, we did a lot of work some time ago because the mother had a social worker, the father had a social worker, the kids had a social worker, and sometimes they were getting 3 different messages as to what the family had to do. And sometimes it was be 2 places at once with 1 automobile. And we did I forget what we called it, but a social worker. So the entire unit. Yeah. And now, I just want to make sure we aren't setting up a system in which you have DCF and the family social worker here. And for whatever reason, the child advocate decides to get involved, which then you get this confrontational thing. And the kid and the family are sitting there because you've got 2 agencies of state government disagree. And
Good question.
yeah,
Yes, and one of the things we're going to try to do is to get the New Hampshire child advocate in here, can ask questions about how she functions and what her work is like. And then that might help. I don't know if it'll help completely. We're also going to get DCF and others in to help answer some of these questions because they're basic questions.
and it may just come down to the adequacy of the staff we have in DCF
And the caseload.
and the caseload, it's the same thing. I don't think we've improved since we did the Child Protection Council and the triage.
Okay. Where are we?
We're on the subsection C, bottom of page 8, top of page 9. We were looking at confidentiality and then the exceptions to confidentiality. So C is another exception that the advocate or deputy advocate may publicly disclose patterns of conduct or repeated incidents identified by the advocate or deputy in carrying out the provisions of this chapter. If the advocate or deputy reasonably believes that public disclosure is likely to mitigate a risk posed to the health, safety, and welfare of a child or youth, except the advocate or deputy advocate shall not publicly disclose either of the following: individually identifiable information about a child or youth, unless the information is already known to the public, and investigation findings where there is a pending law enforcement investigation or prosecution.
Okay. That begins to get at the kids who are adjudicated, but
Yeah, this, I think what this section gets at, if there's a facility and there seems to be a pattern at a particular facility, for example, it doesn't have to be a facility,
right.
but that gives the advocate or deputy advocate to publicly disclose that there's a pattern of behavior at a particular facility or what have you, as long as there's not a pending criminal or law enforcement investigation, there's not individually identifiable information being shared in the course of sharing that allows
Yeah,
some degree of disclosure.
okay. I can see some conflict there too. That'd be interesting. Without going.
Okay, speaking of conflict, section 3209 is conflict of interest.
Oh, there you are.
So let's see, the advocate, this is interesting. So I'm taking us off course a little bit, but I know the question will be, how many employees does the office have? So the legislation itself only talks about or requires the advocate to hire a deputy. But there's this language here, the advocate's employees, which indicate that there could be, there could be. I think it leaves the door open for the advocate to hire. So that's sort of anticipating that you might have questions there. That's how the legislation has addressed it. So the advocate or the advocate's employees, contractors, and members of the Oversight Commission shall not have any conflict of interest with the department or any entity that provides services to children, youths, and families through funds provided by the department relating to the performance of their responsibilities under the chapter. And for the purpose of the section, a conflict of interest exists whenever the advocate or the advocate's employees or contractors has direct involvement in the licensing, certification, or accreditation of a provider or facility, has direct ownership interest in a provider or facility delivering services, is employed by or participates in the management of a provider or facility delivering services, or receives or has the right to receive directly or indirectly remuneration under a compensation arrangement with a provider or facility delivering services. Then we get to the last section of this new chapter, and this hopefully will answer Senator Hooker's question about what is this Oversight Commission and who is on it. So this establishes the Oversight Commission to provide guidance and recommendations to the office. And then in terms of the membership, the commission is composed by the following members who shall not have a conflict of interest with DCF, one member of the House who serves on Human Services and who is appointed by the Speaker, one member of the Senate who serves on Health and Welfare and is appointed by the Committee on Committees, a member with professional expertise in childhood trauma, adverse childhood experiences, or child welfare, who is appointed by the Governor, the Executive Director of Racial Equity, a member of a child advocacy group, board, or commission appointed by the Speaker, a member of an advocacy group, board, or commission who is appointed by the Committee on Committees, a member of a child advocacy group, board, or commission who shall be appointed by the Governor, an adult who is in the custody of DCF within the past 5 years, who is to be appointed by the Vermont Foster and Adoptive Family Association, And lastly, a relative caregiver of a child or youth involved in the child protection system who is to be appointed as Vermont kin as parents. And then in terms of powers and duties of the commission shall recommend qualified applicants for the position of advocate to the governor for consideration, and then provide oversight to the office in its efforts to support an equitable, comprehensive, and coordinated system of services and programs for children, youths, and family. The commission shall have the administrative assistance of the agency of administration. And in terms of meetings, the member representing human services is to call the first meeting of the commission. The commission is to elect a chair at its first meeting. And the majority of the membership constitutes a quorum. In terms of reimbursement, there is reimbursement per diem compensation and reimbursement of expenses for 4 meetings annually. Let's see. And then that brings us to section 2 of the bill, page 13. So this is the language about reporting child abuse and neglect. A mandated reporter is, and then there's a list of who the mandated reporters are. This adds a new subdivision to add an employee of the Office of Child, Youth, and Family Advocate. And section 3, this section governs, yeah.
Quick question on that one, and it's just a question, we don't have to answer or discuss it, but is there anything in here that has reporting, any specific reporting going to the Office of Child Advocate? Anything in the bill that would suggest that when a mandatory reporter reports to, in the line chain of command, wherever it is there anything that suggests that this should report to the Office of Child Advocate?
No, what this bill has is it has that language we went over around in specific incidents is where there's a serious bodily injury, for example, that there's an automatic notice from DCF to the Office of the Child Advocate. And then there's also language that upon request, the advocate can obtain records related to abuse and neglect.
But there's nothing that would say that a school counselor or a priest or any other mandatory reporter would share the information with the Office of Child Advocate.
Not directly, no.
Okay,
no.
All right, well, maybe it's just something to think about. I don't know whether it fits or not.
I would say that the advocate may be able to get that information anyway because they
Yeah.
have the authority to request it, but
Yeah.
not that automatic.
Yeah, okay, all right, thanks.
Jenny?
Yeah,
Because there is a whole system in which reports come in and they are vetted. And then there's another whole informal system that I've had pros and cons with. But yeah, now you've got a child advocate, who if you get a direct report, it could just be a vicious report to get someone to look into your neighbor. So we gotta think that through.
Yeah.
Not all reported child abuse turns out to be child abuse.
right, so it may be the next level. I mean,
Yeah.
obviously, yeah. There needs to be triage somewhere along the way. Okay.
I was trying to look this up while we were talking, but there's the committee and the commission, or the advisory committee, commission. I understand the advisory committee is, sorry, my glasses keep fogging up. The committee is temporary.
Mhm.
I'm without looking at the language side by side, what is the big difference between them?
Okay, so the Oversight Committee, I don't remember which way it's referred to, but the oversight body is, they're like the steering committee. They provide the nominations to the governor, and they're sort of responsible for directing the overall goals and mission of the Office of the Advocate. The advisory council is more like boots on the ground, people with lived experience of maybe being involved in the foster care system or, and they sort of give more guidance on day-to-day operations to the office. That is the committee that is set to expire after, I think, 5 years.
Okay. And are there committees, because it seems like we have a lot of committees in this sort of realm. And I'm wondering if there's already some committee that's doing some of this work that, I remember last year when we had appointments, there was an appointment to something, I can't
Well,
remember.
there's a
what it was.
yeah, there is a child welfare board or child.
Yeah.
Well, it's a board of,
Wait, there's childhood poverty.
Yeah.
Commission, right?
And then there's
Or-
that's different.
Yeah.
Yeah,
Legislative group.
there's the legislative, we're gonna get to that though, because that's set to
Let's
expire.
go
Yeah.
through, let's finish the bill, because then
Okay.
we'll try to sort all this out. We can ask some of these questions. This is good.
Okay.
We need it on Blackboard.
The reason, okay, right here, right there. Katie's only here till 11, so I just wanted to make sure we got through.
Okay, so section
That
3,
clock just got me totally messed up.
the section 3 has to do with who can, upon request, receive department records about records of abuse and neglect. And so Subdivision 6 adds the office of the advocate. Then there's similar language in section 4. This relates to records of juvenile judicial proceedings and who can request records, and the office of child youth and family advocate is added to that list. And then section
So we
5.
can look at kids who are in the court process.
And then section 5 has to do with this sort of like tiered rollout that I was trying to describe. So the office of the advocate only assumes responsibility for the first 2 duties on its list of duties through the first half of the first year it's in effect. So this language has the office beginning on a January 1 start date, because that gives, so maybe I should walk you back further in time to the effective date. So the effective date is July 1. And then there needs to be time for the nominating committee to organize and meet. So then they've done that, the 6 months is given to that. So January 1 is when there's an advocate in place and the office opens. For the first 6 months, the advocate is only doing duties 1 to 2 on the list. So it's a full year from passage that the advocate is taking on the full duties of the office, if that makes sense. Okay.
And are the, sorry, 1 and 2, are they repealed? Or are they
No,
just,
they're ongoing,
they're on?
but it's just sort of narrowing the scope of responsibility and while the office is still underway. I guess the assumption was once the advocate begins on January 1, there needs to be time for a deputy advocate to be hired. There's, more rollout that's needed than just jumping in. Okay. Section 6, the initial term of the advocate is to begin on January 1, 2022. So we'll obviously update that, but that sort of sets the date of the first term. There's an appropriation in section 7 of $120,000 to fund the office. And so you'll remember that that's sort of half a year that the office is up and running because it starts January 1. And I'm sure everyone probably has an update to that. Section 8 is a repeal of the Joint Legislative Child Protection Oversight Committee. If you move forward, I'd recommend just pulling this section out altogether because it's already set to repeal June 1, 2022. This would take effect July 1 and repeal something that has already been expired, and it would create more confusion than if we just took it out. And then we have the effective date language, which is that the act takes effect on January 1, except that the language about access to reports about child abuse and neglect records from the juvenile judicial proceedings. All of that takes effect in January, because the advocate would have no reason to access that before the term begins. That is it.
That's it.
That is
There's a
it, but it's
lot,
a
there's a
lot.
lot, there are a lot of questions in there. So this is good. The office shall act, and I made the notice at the beginning of the bill, it says the office shall act independently of any state agency or organization. But and it's not housed anywhere. We don't, there's no little office space here. So there's nothing about that in the bill. And I'm looking up at Representative Noyes and Representative Collins. Did you talk about where this advocate might live? Where the office might be and how that would be accommodated?
Yes, we did. And we actually looked at having in the Office of the Administration. We even talked about, outside of state government. But what we came up with was just like the Office of Racial Equity that's within state government, but not in any agency.
Right, but Susanna Davis has an office. Yeah, so is there anything in the appropriation that Nolan can answer that
I can
question?
take that on, Representative.
Good.
It does say in section 1,
Thank you, Katie.
let me just come up.
Please, come on up. Yeah, let's go up.
For the record, Nolan, welcome to this office. It says in the beginning that it would receive services, no, sorry, it doesn't say that. Often what happens is, I know that I did with the Ethics Commission and I think the Office of Racial Equity, they get administrative services through agency administration. I'm not sure if it's clear here or not, if you can call. But, and those administrative services are just simple stuff, like they might get some legal help. But I do have in my fiscal note some costs for what it would cost to like staff the office.
Okay, all right, yes, we'll look at that. Well, ultimately, we'll look at that. We'll probably hear testimony from folks about what their thoughts are. Yes.
When I looked at this, I talked to the folks at the Ethics Commission.
Oh, you did,
Just to
okay.
get a sense of like how
Yeah.
they operate and
Yeah.
what their needs are, so.
Okay. But there wasn't a discussion about having like a healthcare advocate where there's a big office building and it's filled with,
Healthcare advocate is a contract outside of state
Yes.
government.
but so that discussion did not happen.
So I'll defer to them.
I'm
but
looking up at the screen. Did that discussion happen?
In terms of where the office should be located,
Or having something like a contracted office? I know that, I think in, looking at Montana, well, one of us contracted here.
yeah,
Is-
Maine has a contracted service.
yeah, we talked about all kinds of different scenarios. Like Colorado has it in the judicial branch, and we talked about it being like the healthcare advocate being at legal aid. We talked about in long-term care ombudsman that's outside of state government as well. So
But okay, and so you did talk about it being in the legal aid, the umbrella.
yeah,
Okay.
and I think what we came down to is we really wanted this office to have access to information and records. And this was the way, if it was within state government, then there would be easy, they would be able to access the information they need in order to make this work. Where if it's outside of state government, it would be a lot harder.
Okay. Thank you. That's helpful. Nolan, thank you. That's great. Anything else that you could think of on that?
No, I mean, you could, and this might be a question for Katie, a lot of times, just like some of these work groups, you
Yeah.
can say get administrative support from
Right.
agency administration, you could add something like that. But nonetheless, it would still need money for
That,
an office.
yeah.
But I have a fiscal note if you want me to go through it, or like,
Go through your fiscal note?
Yeah.
How much time? will that take? That'd be good.
I can do it quickly.
Sure, do that.
Okay. So there is a fiscal note, and what I did was, I looked, as I mentioned, I looked at, and this is a year ago, so I'm digging into catacombs.
Oh, yeah,
And so for one, I assumed that it would need 2 staff. Actually, let's just go to the back. So let's just do the summary. We'll go to the last page, and the second page of my fiscal note, where I have the summary.
got it.
So I built in the advocate wages and benefits, and I did a high-low, and Senator Cummings, the average is about 100,000. So wages and benefits for an advocate, wages and benefits for deputy advocate, and that came out of a conversation I had with several folks trying to dig against my catacombs, where there's too much work for one person.
Yes.
So the sense that there would also be a deputy advocate, because the language allows or requires the deputy advocate to be hired. And then I built in money for rented space, equipment, phones, purchase of service, travel, etc. So that those are all things that you would need to run an office to provide this thing. And this came again out of conversations I had with some of the offices who felt we didn't feel, but they didn't have the resources that they need to do the work. So I wanted to make sure that this had the resources. Then you have your per diems for the advisory council members. That's
Is that cumulative or is that 1 year?
It's all 1 year.
Okay.
And then your per diems for your advisory council members and your commission members. And then I believe it had an effective date in January, so it's a half-year cost. So totally annualized is between $200,000 and $300,000. But since that had a January 1 start date, it would be half of that. It's half the year.
Got it.
So that's the quick.
That's a quick one.
Now, the other thing I'll throw out is that this bill has an appropriation, but there was no appropriation in the budget because it came over, but it's been passed. So it wasn't built into the budget context. So I sort of flagged it over. It gets complicated when that happens. So I sort of flagged it over there at the House saying, hey, you passed this bill that has an appropriation. And should the Senate decide to concur, you have to build that into your budget construct.
So did the House Appropriations Committee never actually looked at it?
Well, the bill was passed, but this.
Didn't they?
But they passed it last year, and then because the bill didn't come out of the Senate, it wasn't built into the budget construct. So that's what complicates it, is now they're thinking about their budget construct for now. Oh, wait, there's a bill that might pass in the Senate that has to sort of be taken into consideration.
Do you know if they're putting it in?
I don't know. I flagged it for somebody over there.
But so when we got, that was the one thing I was gonna ask you today, is that when the budget looks like it's done over there, we should have someone in to talk to us through.
I think the answer is there's a lot of pieces that there's a list. And I think this is one of those things that should the Senate pass it, it would be obviously a piece that we have to reconcile within conference, right? So, but I do think that, it definitely needs an appropriation.
Okay. Any
There's my
other
2
questions for Nolan? Okay, this is good, thank you. We got some kind of a picture now. As we start taking testimony, we'll be able to answer some of the questions we have. And thank you also for the list of the other states, that's very useful. So Jen is coming in at 11:15, why don't we take a little break? We'll take a break.